Chapter 6, Intellectual Property. Part 3, Patents. The learning outcomes include: explain protections offered by patents, explore enforcement of patent IP rights, trace the evolution of patent protections, illustrated technology-related ideas that use patents, demonstrate the role played by prior art for patents, analyze cross-licensing and lawsuits. For a patent to be considered, it must be novel, non-obvious, and a proper subject for protection. Section 1 states that all useful things made by human ingenuity are patentable, while those bestowed by nature are not. Patents last for limited periods of time, and times vary around the world. The U.S. Patent and Trademark Office grants exclusive rights for a period of time. In exchange, the patent seeker publishes the method, device, or process that is the subject of protection, thus encouraging competition, but only after the patent protection time has passed. Why would you or your organization file for a patent? Unlike copyrights, patents protect even independent creation and copying. Even if you come up with something on your own without any knowledge of the patent, you are not able to act on it if the other person has a patent. To bring forward a case against someone for patent infringement, you must have an application filed with the USPTO. Part of filing for an application is doing an exhaustive search for prior art. That is, have others already received a patent for your application? The USPTO examiners may not be familiar with IT and may overlook some relevant prior art. However, Apple and Macintosh will not overlook a potential patent infringement. You and your legal team must complete a prior art search. Patents for software protects the features, functions, and/or processes that do something on a computer or cell phone. If people infringe, who's responsible to find them? You. You must protect your own intellectual property. Literal infringement is evaluated by determining if someone is making, using, or selling something in the U.S. that is protected and is your intellectual property. The rule of exactness is the easiest condition to evaluate. Does someone else make, use, or sell an item that is exactly like yours? The rule of addition is a little more difficult to determine. It's when someone makes, uses, or sells an item that includes the elements of the IP, but also has other elements. Is it different enough from your IP to be considered a different product? Finally, the rule of omission states that the product does not infringe if the item leaves out any of the elements of the original IP. Another way to evaluate infringement is looking at the doctrine of equivalence. This is when someone leaves out an element from your IP and puts in something that is almost identical. This isn't allowed. It's considered infringement. If it performs substantially the same function in substantially the same way, then you are probably infringing. As mentioned, with prior art, you are responsible for searching for other similar items to make sure that what you want to patent is eligible. As I said earlier, your competitors will be highly motivated to keep you from getting close to their IP. You have to do a thorough search of prior art, realizing that the PTO has limited resources. Does this look familiar? 2 all beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. This is what McDonald's submitted for the original patent request for the Big Mac. And the iPod, which ultimately led to the iPhone. Sometimes patents are hard to understand what they're trying to protect. For this one, I have no idea what it is they're trying to protect. Some sort of process, I guess? Until the last 20 or so years, business methods were not patentable. With the advent of technology and changes in patents, business methods are eligible for patent protection. In this case, Amazon took Barnes & Noble to court. Amazon's buy it now with one-click process was patented, and Amazon sued Barnes & Noble for patent infringement. Barnes & Noble was using an express lane option. Amazon asked the court to bar Barnes & Noble from using a one-click technique. If we think about it now, the one-click technique sounds perfectly logical and not novel or non-obvious. However, at the time, nobody else had done it, and it was granted a patent. The district court found that Amazon's patent was a commercial success, solved a problem with shopping carts, was quickly copied by competitors, and that Amazon would likely win on the issue of patent validity. Thus, a preliminary injunction was issued. You may have heard of these companies, Apple and Samsung. They are constantly battling in court in the U.S., South Korea, and around the world, claiming that the other one is infringing on IP. In 2016, a lower court in the U.S. ordered Samsung to pay Apple $399 million in damages for violating design patents that exist on the iPhone's shape and colorful icons. For the first time in over 100 years, the Supreme Court agreed to review a design patent case. In an 8-0 verdict, they concluded that Samsung may not owe Apple all profits from the smartphones that were copied. They sent the case back to the lower court to decide if only components were infringed upon and not the entire product. Then the award may need to be reduced. After the verdict, Apple complained about the blatant copying of our ideas and hopes lower courts will again send a powerful signal that stealing isn't right. In contrast, Samsung noted that a smartphone is smart because it contains hundreds of thousands of the technologies that make it work. Their point, there are many components to a smartphone, and looking at just a few doesn't give a valid picture of IP. Cross-licensing is a practice used by many large technology organizations. With cross-licensing, each side agrees not to sue the other over patent infringements. That way, they aren't in court all the time, like Apple and Samsung. Small businesses may find that cross-licensing agreements are out of their budget, and thus may end up in court against companies with much larger legal budgets. The small company often agrees to license its patents to the large company, avoiding lawsuits and profiting from its IP while allowing the larger company to introduce a product without fear of legal challenges. In summary, technology is treated like other inventions in terms of U.S. patent law. International rules vary. Technology patents have only been patented for the last 20 or so years in the U.S. Internet business methods may also be eligible for patent protection, although we are seeing a decline in approvals for these types of patents. Businesses must do a thorough search of prior art before applying for a patent. The USPTO cannot and will not do it for you, but your competitors will. Cross-licensing agreements may limit lawsuits filed, and they are particularly popular among large companies.